Just as a way of introduction, it's an honor to be with you again. I've been with you for almost 25 years with no failure and great success. We've had very tough issues before us. We spent a lot of time and resources on a few of them, but we were ultimately successful. We have important work to do. The reason for us being here today is to not to hear a lecture, but to engage in a workshop. Materials that have been put together, these are tried and true materials, and we focused on the practical, the application of the law in a very sensitive way. We don't want to be engaged in projects that don't have a reasonable chance of success. Our law is too precious to go before the court with bad cases. That's always been my concern, and I think it's worked out very well. For example, with the recent Bank Street case, we've had a lot of publicity on that, as we do in most cases. That has provided a chilling effect, I've been told, to many developers who want to destroy historical properties. Think of the reverse of that. If we would have lost the Bank Street case, what the ripple effects of that would be. So that's what we have to be sensitive to, from my perspective as a litigator and as your counsel. Jack Shanahan has been really the number one reason we're in this position now. He formulated the beginnings of what we know as the CEPA, or the Historic Preservation Council, and we've engaged with hundreds, if not even more, of these matters. And he has a memory that I envy. Whenever I would ask him a question, he would put his hand on a document. So without further ado, I'd just turn over to Jack to give us the history, maybe have some stories about some of the cases that we've done, and move from there. Okay. Thank you.
Thank you very much, Alan. The state of Connecticut typically has had various task forces over the years that look at clean water, open space, all sorts of topics involved with the environment in particular. And in 1979, the Department of Environmental Protection, or DEEP as it's called today, approached us about having a new task force on heritage. And at the time, we thought that was interesting. It would involve the DEP, as it was called then, the Commission on the Arts, and the Connecticut Historical Commission. The idea was legislation would be introduced. It was called the Governor's Heritage Task Force. Governor Elliott Grasso was behind this bill. It was introduced in 1980. They appointed, the law passed, they appointed a committee of 25 public members of this group, and some 9 agency staff people were assigned to the task force. The late Terry Tondreau, professor of law at UConn Law School, was appointed as the chairman of the task force. And we began our work by having public meetings around the state of Connecticut to solicit public input about what concerns people about saving historic resources. And if I had to summarize those public meetings, I would say it would be 2 things: money and protection. Those were the constant arguments that people threw out and said, we need to be able to protect our historic resources, and besides, where can we get some money to save the resources that we're struggling with right now? Out of those hearings, Professor Tondreau assembled a group of environmental attorneys to guide the task force, and they came back with a recommendation that the problem was that the only protections we had at that time were for local historic districts, which are still the best tool that we have in Connecticut to protect historic resources, and the review that's required for federal projects and programs under the National Historic Preservation Act. But there was no requirement for the state of Connecticut, that is the Historical Commission, to review any actions of the state of Connecticut. And there was no way in which you could really challenge somebody in the courts that might be threatening a private citizen or developer proposing to demolish a historic building. So out of that task force, they issued a report of about 42 different recommendations in here. But one of those was that we needed to have legal standing in the courts. And to achieve that, we had to seek an amendment to the Connecticut Environmental Protection Act to bring into place the language that would be necessary. So 1982, we had an organization that's still in business today, almost 40 years old. Connecticut Preservation Action has been working over these 40 years to achieve legislative objectives and tools for historic preservation, and they were successful in getting both an amendment to the Connecticut Environmental Policy Act that would allow the Connecticut Historical Commission, now the SHPO office, to review state projects, and the Connecticut Environmental Protection Act. Well, the law sat on the books for about 3 or 4 years, and nobody had used it. Nobody really threatened to use it. And finally, an attorney called one day and talked to me in Norwich, Connecticut. He said he was concerned about the former state armory down there, and that had been turned over to the city of Norwich, and there was a proposal to demolish it, and citizens in the community had organized around opposing that. And was there any law that could be used to challenge that? And because the property was, I don't remember now because it's too many years ago, whether it was listed or under consideration, but in any case, they attempted to use the law. They were not successful, primarily because they couldn't convince the courts that they had a feasible and prudent alternative to use the building. And, you know, that was the first case. A subsequent case in Wallingford, Connecticut, a building that was threatened to form a library building there. We didn't succeed in that case, or it was, I should say, that was those were both private cases where attorneys were represented local groups. And they were unsuccessful, although the building was saved, it was moved down the street. And wanting to know more about this, I requested an opinion at that time. Joe Lieberman was the Attorney General. I requested a legal opinion about various aspects of this law that would help guide us in interpreting our role in the public's role in using it. That was a very helpful guidance for me as a state agency head, but more importantly, it was helpful to the public to understand what might happen. Subsequent to that, Attorney General Lieberman contacted our office and asked if we could take up the matter of a threatened building in the city of Bridgeport that was owned by the Archdiocese of Bridgeport. And we said we would get involved and so forth, and we did get involved. We didn't win that case either, but we were learning as we went along. And more importantly, we had assistance from the Attorney General's office in helping us formulate the best strategies that one could use for this case. And in 1989, we actually won our first case here in Hartford on the South Green. Sadly to say, the building was burned after that. And so we didn't have a lot to point to. But the Attorney General's office appointed Assistant Attorney General Larry Russ, and subsequent to that, Alan Panansky joined the agency. And for 20, as Alan says, for 25 years plus, we've had the support of all three previous Attorney Generals in helping the agency. And you should understand that this law was very unique. It was the only law of its kind in the nation at the time it was enacted, although a subsequent law in the state of Kansas had a different broad interpretation. I understand that there are some other states that have subsequently passed legislation to protect National Register properties. And that's the important thing that I overlooked to say at the beginning. This is for properties listed on the National Register, either individually or as a contributing property to a National Register district, number one. And number two, a property that's under consideration for listing on the National Register of Historic Places. And that's always one of the most difficult words, is under consideration. That and the other word you'll see in the law is what's unreasonable. And So that's good fodder for all the attorneys around, and Alan has wrestled with these terms for some time. But I can't say enough about how important it has been to have this law on our books, because without that, what does the National Register really mean in terms of protecting threats from private sector to National Register listed properties? It doesn't exist. As much as important, you think of all the work that goes into documenting and listing properties on the National Register, and if all you can do is photograph it before they take it down, that's a sad testimony. And it doesn't mean that every historic building should be preserved or will be preserved. In fact, the National Register doesn't even say that. It says worthy of preservation. These are properties worthy of preservation. And each building or property or district has its own story and facts that will help it be preserved for the future. But one of the most important things, and Alan will tell us, I'm sure, in his remarks, is there has to be a constituency out there that cares about these properties. This is privately, in a sense, attorney generals are elected officials. What do elected officials count? Noses. Does anybody care about this property? Well, if you have a lot of folks in your town or neighborhood that are concerned, get a petition going. Let's see what the strength of that interest is locally, because that will be helpful down the road if you're trying to convince this council that it's unreasonable and that people care about it, or if you want the Attorney General's office to take up the matter. And I can't say enough about that, because it's just a key thing. Alan uses the word shepherd in many regards, and the shepherd is just that. It's the one that's going to convince everybody and carry this thing from the beginning. You just can't say, oh, they're going to demolish it. Give you some examples of some of the stories. We had a situation where the city of Milford, Connecticut wanted to demolish a former high school on the town green in Milford, and the citizens rose up about it. We took the matter up before the council. The council, after hearing testimony from the city of Milford, voted to seek the assistance of the Attorney General's office. And the very next week, the town of Milford called up the Attorney General's office and said, we surrender, we don't want to fight this thing. And sometimes that can be the most useful thing, is just putting your foot down and saying, this one we're not going to accept its demolition. So we had another situation where a religious group, came before the council, what was called the commission in those days, came before the commission, said they wanted to take the rectory building down, and they really weren't prepared that first day. Could they possibly postpone the action till the next meeting? That seemed reasonable. We've always granted that. Guess what happened between that date and the next meeting? The building was demolished. How can you stop, how can you slow those things down? Well, one of the most important tools we have to assist this law are what we call demolition delay ordinances. And today, what they are, can be held up as long as 120 days, I guess.
180.
80?
180.
180. That's, I don't know if any communities have adopted that, but that's a wonderful tool,
Westport.
because if you have that time, you can do a lot of things. And most importantly, you can have a presentation before the council to consider that fact without the pressure of saying, well, they're going to run out next week and tear it down. And so that's another piece of legislation that is hand and foot with the protection law itself. I would close my remarks at this point, because I know we got a lot to cover today, to just remind people that it takes somebody who's concerned. The former chairman of the Connecticut Historical Commission for many years, they have an award they created from the Harlan Griswold. He was quoted many years ago. He was on the National Trust Board. He says, it takes a lot of angry women to stop the demolition of historic buildings. And he had cited all these cases where these individuals had stepped forward over time and said, no, this is it, you're not going to tear this one down. And that's not proper today just to say women, but it takes advocates at the local level, and we have a couple of advocates with us today that are working at the vineyards and trying to keep these resources preserved. So I'll be glad to answer questions at any time. I have a couple of just handouts that I'll pass around. I have that excerpt from the Heritage Task Force about the law and the subsequent piece of legislation. I have an article. This was very helpful in the early days when Joe Lieberman did a piece here for the value of this law. And
A good quote from Churchill, by the way.
yes. And
Oh, yeah.
the last case that I was involved with, at least that was successful, was the Capitol building here on the green here at the Bushnell Park in Hartford. And that, there was an editorial in the Hartford Courant about that. It has been rehabilitated and saved. And I can't say enough about the assistance of the Attorney General's office and
Yeah, like what Jack said, he hit all the keys. There has to be community support for the resource. There has to be a shepherd. There has to be an identified, prudent, feasible alternative. You can talk about it, but you have to show it. And is that our burden? No, it's not. It's the burden of someone who comes before us. But when I go to court, I always take up that burden. That's why we win. You have to, like Robert E. Lee, you have to keep the initiative and you win battles. If you give that up, you're going to lose. So what we do is we make sure that we do all the due diligence at every level, and that when we go to trial, we're totally prepared, and we have our team. And every bit of litigation I've been involved with, we've had a team, and that's the successful approach. So if you deviate from the formula, I don't think you're going to win. I know that the cases, the historical cases that we have on the books that we weren't involved with, they've all lost. And they would call me, the lawyer, and say, well, I have this and that. I said, you're going to lose her. You're not going to win. And well, why not? And I would tell them. It would still go anyway. One of the things that come to mind was the Hill House case. That one. So what my remarks would be at this point is really that's a kind of an overview of the practical review of our cases with the law. But to give you an overview of the legal concepts for CEPA, as Jack noted, we've done something very special here in Connecticut. We consider historic resources as a natural resource of the state of Connecticut in trust to the people and to be guarded against unreasonable destruction. That's codified in the statutes that you have before you in the binder. That's powerful. So we can litigate these things as someone would litigate someone trying to pollute the water or the air or the land. And we have to show, I think it's both a heavy burden to go forward because you have to have all your facts straight and your analysis correct. But it also is overwhelming to the opposition because we're taking their burden and we're going forward with it. Every case I've been with, the courts are reluctant to grant this because they have concerns about property rights and telling someone to do telling someone to do certain things to their property. So with that in mind, we've been very judicious on the cases that we go to seek an injunction on. In some cases, the injunction was secured very quickly in an afternoon. I remember Judge Satter and Judge Sullivan in New Haven, which was a very unforgettable experience because when he came, he was completely hostile to us. He thought we were un-American.
yeah.
He said point blank, "Is this America? How can you do this?" And I would say, "Your Honor, we can do it respectfully. If you would read my brief and visit the property you will agree with me. He said, well, that's to be seen. I'm going to have a recess and see you at 1:30. So we came back 1:30, and he was looking kind of sheepish, and he said, I hate to say this, but I agree with the Attorney General. I order the injunction. It's all in the presentation. It's tough for any judge, and I see them squirm because they've never had any experience with this law, to come in and they don't want to be with you. They want to be on the other side. They're for property rights, securing, and they think that we're here to save every building that's historic. We're not. As Jack mentioned, the vast majority of historic buildings are on the National Register. On the State Register. And those have no legal protection. They're just honorary. They may lead to something else, but it's the ones that are on the National Register or under consideration or a part of the district. And if you turn the page to the statutes, you can identify that. First of all, on 22A15, you have a declaring of natural resources, and that this historic preservation is part of the natural resources. And then on the second page on 22A16, the action that you can take against unreasonable, look at it, says unreasonable pollution. It's unreasonable destruction as well. And that citation is I just would point out that if you read it in detail, yes, it's the Attorney General that would take the action, but anyone can take the action. The Connecticut Historic Trust, which take actions on their own, which we've joined them later, or a person can do it. The problem is that there has to be bonds posted if you go at it without state involvement, and that was a nagging issue, I think, in the Norwalk case.
Yeah, well, you guys came in 24 hours after we did.
Right.
Saved our butts.
Right, and we said that we, full faith and credit of the state of Connecticut, and we don't need a bond. And that the reason they have a bond, requirement for a bond, is they don't want you to be a gadfly going in there and stopping someone, and you don't really have a case. They're gonna say, if you do that, you're gonna get whacked. We're going to seize your bond. We're gonna do some things to you.
And the bond is actually paying for the cost of the litigation?
No, it's just posting that you will complete your litigation. Because what I think would happen in the past is that they've had people come in to try to stop a demolition with no intention of really going forward with the litigation because of the cost. So, we get away from that. There are times when the Attorney General refuses to get involved, even after a referral. We've had that for whatever reasons, whether it was political or a bad case or whatever. And other individuals have stepped in and they lost. And it's something that we should focus on, the fact that this tool of injunction is open to everyone. I like to lead it, or the Office of Attorney General would like to lead it in coordination with all our friends here, because we're going to be successful. The worst thing you can have is bad precedents, even on a state court level, a superior court level. We don't have that per se. We have a couple of cases that talk about historic fabric, which that's the Hill House case, which the judge, in my mind, in my view, really shouldn't have gotten into, because he's not a trained historian or in that field. That's something that's already been vetted. But my point is that you have to be very careful with cases that you push forward. I know that in other practices that I do outside of historic preservation, that the Connecticut Bar, without mentioning the area or individuals, they had a tremendous litigation going for a certain field, and there's nothing we could do about it because the law wasn't established. So they got, I would say, greedy, and they started pushing appeals to the appellate court when they didn't win. And that's the worst thing they could possibly have done. The court was fed up with it and came down with stringent guidelines on that particular area. So the whole litigation dried up, and lawyers now couldn't have those avenues. The very same thing could happen to this law. We don't, when we were in the last case with the Bank Street case, the judge was surprised and impressed that there wasn't any appellate court cases on this law. And he's asked me why. I said, it's quite simple, Your Honor. The law is very clear, and we are very judicious in applying the law. Of all the things that go out in the field with all the conflicts and historic preservation, and we work it out. But with those who are unreasonable, both in their alternatives and their outlooks, we take them to court. But most of the times we work things out, and I think that was the hallmark of our years here. If we can't, if we see that there are no prudent or feasible alternatives to demolition, we don't vote for the demolition. We just turn down the resolution. In those cases where we're uncertain where to go, we just continue the matter. And we give what I call homework assignments, and until we know the whole story, and then we can make a decision. If someone comes, and we've had this many times, they come in unprepared, we say, well, we can't, you have to answer all these other matters. When can you come back? Is there a stay in place? If there's no stay in place, we get assurances from their attorney that nothing's going to happen to the house. How the law works on this presentation, it talks about the powers of the court, and on 22A, 19A, historical structures and landmarks, it talks about the unreasonable destruction of historic structures and landmarks, and it talks about whether they're listed individually or as part of the district or under consideration. And the court always asks, every judge asks the same question, well, is this individually listed? And I said, Your Honor, it doesn't matter if it's individually listed, if George Washington slept there. It doesn't matter. What matters is that the statute clearly says that there are three categories of resources that are protected against unreasonable demolition or destruction. It doesn't get into the weighing of those resources. They're on the list, that's all we need to know, and we just move on. And that cuts the whole discussion about historic fabric and what's its place in history. I think with the Bank Street case, he was, the fellow attorney was trying to go into, well, what year is this resource? Is it 1820? Is it, well, it's many different dates, but the date that we're focused on is the date it was put on the register. That's the important date. It's the date on the register. And we also, when we have a property that's in a district, we have to put it, as Todd would know, we have to put it before the Preservation Board to recertify. You got to follow the statute. The statute commands that. So in the Bank Street case, we made sure we did that before the judge reviewed it. So we're following exactly the law. And that's the problem with persons or other people doing these cases. They're not really focused on the nuances. And they get siphoned off into areas that will be detrimental to their case, because every historic building looks like a mess when you're in there. And they showed the pictures. And my response is, Your Honor, I've seen far worse buildings that have been restored. They look great, and everyone's happy. It's a win-win-win. That's what we strive for. We don't try to say, oh, you can't take down this building, and that's the end of it. What we do is we, as a body, you're all various professions that surround historic preservation, and you're all able to contribute to possible solutions for people who come before us and things they haven't really thought about. And I think the chairs used to say, well, have you thought about this? Have you thought about that? And those become prudent and feasible alternatives. Under consideration has come before us many times. It's really focused on when is it really before the commission or the council and the processes that are here. That's been identified in the AG's opinion, as Jack has pointed out. Has been refined in several cases. With the Hill House case, went into great lengths to discuss it. There has been, I think, a Norwich case, as a footnote, went into it. And the staff has really focused in on the process of doing this. So I think we're in good shape with respect to when something's under consideration. Just know that there's never been a pronouncement on that particular term by an appellate court. It's been pronounced by the agency has a right to interpret its own statutes. Then it's been asked for Attorney General opinion, which now becomes the focus of how this thing works. And then it's been further refined through a couple of judicial decisions. But know that with judicial decisions on a Superior Court level, other courts don't need to follow it. They can come to their own determination of what that means for their own purposes. So I think we're good staying with the AG's opinion, but we need to look at the refinements and the point of views of the court, because easily a lawyer could say, well, that's all true, but I would encourage the court to follow your brethren and determine it this way. Now, this may sound nuanced, but there's been cases where your standing comes into play, whether you can bring this action under consideration. The solution is to identify the problem way in advance and then set the mechanisms up to make sure that it's under consideration, that you're not going to have any problems. What does have a problem is 11th hour, you get a call, they're taking down the old Capitol building. And it's not on any register. It's not even close to a district. There's no district there. I think with the Capitol building, the one that was Jack passed around, that was a building not on any register, but there was a commercial district?
Yeah, commercial district.
Of 2 buildings. And the Capitol building was put in there under consideration. And in the district, you don't need the consent of the owner. You just need a majority of the owners to approve it. So what happened there was, Capitol building said no, another building said yes, and the other building didn't vote or didn't respond. So what happened was, in the event of a tie, we win. So it got us protection, and that's what I had to argue. And I showed the statute and so forth, and Judge Sada said, yes, I agree. And we put in the feasible and prudent alternative, which was, I think, Bruce Becker came in, and we won. That was another afternoon delight. I mean, it was fantastic. But that wasn't the end of it. They tried to take the building off the register through the keeper of the trust. And to do that, you have to go through through the State Historic Preservation Office. And the keeper said no, and the whole thing was appealed, but finally it all ended up great at the Second Circuit where we won. The next section of this is the preservation law update, which talks about the cases and how they set standards for anyone thinking about taking down the building. With that, I would just, before I move on, if there are any questions about what's been said so far? Yes?
The consequences. If something comes down, what's the consequences of the owner at the end of the day? How does this get directed to the Attorney General's? Because people ask me, well, I'm going to take it down, what are they going to do to me? It's as simple as that.
Well, the least that's going to happen is we're going to go back for the grant. That's the least that's going to happen. The other is damages for breach of contract. It could be the entire worth of that resource as determined by an appraiser. So there are consequences. Once they signed a restriction with us, we enforce it. We enforce those restrictions. We're investing taxpayer money in a historic resource, and we expect that our investment is going to be protected. It's there's a big difference between having an accident, whether a tree falls on the property or a fire or whatever, but someone purposely going out, knowing they had these obligations and taking down the building, they have, in my view, they have serious exposure. So in that case, you should notify your Attorney General, me, or my successor, and tell us what went on. Give us exhibits, and we can bring it. We can look at it, see what we can do. But just on first blush, I said this. I think there's a lot we can do.
Let me just
Yes,
jump in.
Tom.
So what you're saying though is with a preservation restriction that comes with one of our grants. That's what you're describing as an answer. I think what you were saying though, forget about the preservation restriction. So let's just say New London, Bank Street. In the middle of the night, he knocked down the buildings before we went to court. Then what can we do?
Well, first of all, he's in contempt of court, so he
Even before we have
could
gone
end
to
up
court?
in jail.
But if we haven't gone to court yet. Before we saw, so we go to our meeting at HBC, we say, the HBC votes to bring it to the Attorney General's office. Tomorrow, the next day before we go to court or even meet with him, he knocks it down.
Well, in that scenario, there's no court order. We're anticipating this is kind of a race. Once we file it, there's still no protection unless you get a stay order. And if you go for an injunction, you do get a stay order. You can either go get a stay order, or you can go right for the injunction within 5 to 7 business days. Okay, so I'm going to turn this over to Kathy, just to say a few words on the role of the staff, and then I'll come in.
It's sometimes a difficult role because you're weighing people who are extremely emotionally invested in something against factual evidence. And so sometimes we have to balance those things to determine what the best path forward is. But we do have an established process, so I will let Todd speak to how procedurally we handle it in office.
Also, the Connecticut Trust role too in doing some of that outreach.
Yeah, that will.
Yeah, so what happens generally is we will be notified either from individuals who are interested in preserving an endangered building, or it'll come through the Connecticut Trust, that they are contacted that, hey, listen, this building is important to us, it's threatened with demolition, is there anything we can do? And either myself or staff from the Connecticut Trust will say, there's a law, this is what it is, the Connecticut Environmental Protection Act. If your building is listed on the National Register or under consideration for listing as defined by law or on procedure now at the Attorney General's office, then you can go forward with this process. And we explain to these people what that process is, right? This is how the law works. Anybody can invoke the law Or there's another process in which case we are shown, the State Historic Preservation Office is shown community support, outrage at the destruction of this building, in which case we will, at SHPO staff with the partnership of the Connecticut Trust, will begin to investigate. So we will send a letter to the owner asking them to fill out a questionnaire and provide any documentation on what they've done to the building and why they want to destroy it, and have they tried to rehab it, etc. That documents in the packet. And then we'll gather up all the information we can find, any kind of reports, and the history of the building, and how we got from a building that is in service to where it is now, where it's threatened by demolition. So myself and usually Brad from the Connecticut Trust will gather all this information. We'll put it in a packet and submit it to the Historic Preservation Council. The Historic Preservation Council, at one of your meetings, we will ask all the players to come and make a presentation. So the way it works is you'll have this packet, and in fact, you're going to have a packet in your Dropbox on Friday for our meeting on March 6th. We usually like to get it a couple weeks before. Unfortunately, timing did not work really well for this one. But anyway, you're going to have a packet that's going to have a history of the building and the narrative of how it got from a building that is in service to a building that now is in danger of demolition. And we're going to call them a plaintiff and a defendant, although this is not a court of law, but the proponents for preservation and the proponents for destruction of the building will have an opportunity to give their case. So we usually open up with, I think, the defendant, right? It was the Connecticut Trust who opened up last time. I think we've shifted it sometimes. And in fact, that's a discussion that we should have too, Sarah, because in this case on Wednesday, Willimantic wants to open. They don't want to go second. But anyway, each main person has 20 minutes to give their case. And they can bring in their architects and engineers on that 20-minute period of time. And then the plaintiff or defendant, if we switch it around, will have an opportunity to give their side of the story. And then everybody else has up to 5 minutes who wants to make a statement on why these buildings are important, and we ask people not to be redundant. So if somebody already said, this is an important building, it's listed on the National Register, we're not going to allow journalists who else to say the same thing. They can submit written statements. So while this goes on, the Historic Preservation Council will have the opportunity to ask questions and have a discussion. When all their questions are answered, they will then, the chair will then propose a vote. Do we want to bring this to the attention of the Attorney General's office? And if the vote is affirmative, then the Attorney General's office is asked to investigate. The next step would be that now Alan and I meet with the owners of the building and see if we can work out some kind of agreement to save the building, because we never want to go to court. The last thing we want to do is go to court, because it's time consuming at the staff level, the Attorney General's level, and it costs money. So we always try to work it out. And we've been really successful in working it out. Even before it goes to the Historic Preservation Council, oftentimes proponents for demolition will say, lawsuit, all right, you know what, maybe I'll go to the table now and talk to you about some of these other historic preservation options. Because CEPA offers money. We have tax credits and we have grants that we offer to these folks. So when the Attorney General's office, though, is sitting at the table, the owners generally listen, or at least more apt to listen. And we try to work out an agreement where we save the building. If still they're unable or unwilling to do so, then we go to court.
And the other thing is, we need to identify, before we go to court, we need to find not many, but just one prudent, feasible alternative that we can show. We have to have that, or we don't go forward with the case.
Yeah.
Yeah, I was going to say, so SHPO's role in this is really more of a conduit. So when Alan and Jack were talking about the importance of having a shepherd, we are not that shepherd. What it really relies upon is individuals in the community that are willing to go through this entire process and shepherd it through those process. And all we do is act as a conduit between linking the community to the Attorney General's office to make a solid case in terms of the community support. We rely upon the expertise of people through the Connecticut Trust and helping us put together that argument of feasible alternatives. And so really SHPO just acts as kind of this bringing everybody together and pulling all the information together so that we can bring it before the HPC for referral.
And similarly, the trust as well would be, they wouldn't take on the role of shepherd either.
Generally not.
Generally,
No.
Yeah,
it's-
well, I think there was generally not. The short answer is no. I mean, in some cases, they have a revolving loan fund. So we have asked them to potentially use that in CEPA cases. And I think in Norwich they almost did, but then the funding came together.
Yeah, I don't recall any case that we won that, I mean, all cases that we had, we won, but I never recall a case without a shepherd. You got two world-class shepherds right here. They'll tell you the story, but yeah, we don't shepherd here. The trust doesn't shepherd. It has to be local, because that's the only way you can win, is local.
Yeah, I mean, it gets to the heart of the law, which is these items are placed in public trust. And what the law is saying to us, and what the government has affirmed, is that these buildings are so important to everybody that they actually trump individual rights in this country, which is a huge deal.
A huge deal.
So if you don't have that large community-based support, how can you prove that these are in public trust, that the community really cares about them and that they serve a public benefit? And that's why that shepherding and having a large number of petition signatures and a large amount of support becomes very important for the case.
Technical expertise is incredibly important. As we have heard, the language of CEPA demands that you show that saving a building is feasible. And that means that you need a structural engineer most likely to come in, assess the building, and say whether it is salvageable or whether it's at this point a lost cause. And you need to show that it is prudent. And for that, you probably need an architect, and you need somebody with experience with development budgets and a cost estimator, and I didn't know anything about any of this. So we really relied heavily on Connecticut Trust to come in and provide all this for us. But the heart of CEPA isn't technical. The heart of CEPA is about the tension that exists between private property rights and the public good. You don't need to be a technician to understand that. And as Alan has said, although CEPA states that all buildings listed on the National Register of Historic Places, either individually or as a contributing resource, are protected under CEPA, practically speaking, the state does not have the resources with which to pursue all of these cases. And so they need to know that the public cares, and although you spoke about this being important for elected officials, it's important for the Preservation Council as well, because you are weighing these two things. How feasible, how prudent is it to save the buildings, and just how great is the public good? And so I saw my role as not just coordinating what Connecticut Trust was doing and making sure that we could make a case that there were feasible, prudent alternatives, but that the public support for saving this building, which quite quickly became two buildings because the property owner almost immediately took out a second demolition permit application, applied for a second demo permit. I wanted to show that public support was broad, that we had the numbers, and that those numbers encompassed individuals and institutions and the press and elected officials. And I also wanted to show that that support was intense. It wasn't always just a person, some friend of somebody who was on our board of directors signing a petition so that somebody would go away from their doorstep or something. That people actually really cared about this. And so the advocacy part comes with explaining the value of the buildings and showing that we have these alternatives. But the community organizing comes in because the community organizer is the instrument by which the public makes itself heard. And when you're talking about CEPA cases, the community organizer isn't working on behalf of buildings, right? We're working on behalf of people who are very afraid of losing something that matters to them. And I think that's what inspired me to put so many hours into this, and probably what inspires all of us when we connect to that. So to organize all of this, I needed time. And fortunately, New London has a very strong demolition delay ordinance. When we go before our local historic district, they have the authority to impose a 180-day demolition delay, and we used every bit of that. So mission number one was to make my case to them. That involved researching the buildings, putting together whatever we could that quickly about the feasibility and the prudence of the alternatives. And I thought that this was going to be a slam dunk because our demolition delay ordinance states very clearly that the Historic District Commission shall, not might, not may, shall impose the demolition delay if the buildings have historic significance. It turns out that, like everybody else, they are very swayed by public opinion. And they didn't care that it was listed on the National Register of Historic Places, not particularly. They were much more concerned that the building had been vacant, that they didn't know the condition of the building. They were concerned that they were going to be seen as obstructionists to potential economic development. And finally, very skeptically, in my opinion, the city liaison to the Historic District Commission turned to me and he said, well, do you have public support for saving this building? I said, I don't know. I need a demolition delay imposed so that I have time to find out. And they thought that that was fair. And I will say, too, that it probably worked in our favor that we weren't necessarily slowing anything down with this because the property owner hadn't brought in any plans for what he intended to do. So immediately, I already had my story lined up for the narrative of the buildings and why they were important and all of that in the photos, and I had a petition lined up and ready to go, and I released that immediately. But then immediately, the property owner was ticked off and took out the application for the permit for the second building. So we scrapped the first one, the first petition. We started researching the second building, making our second case. Went before the Historic District Commission at their next meeting. This time it was a slam dunk because this building, the second building, was occupied. It didn't have obvious structural damage, and it was occupied by a thriving, very popular local business. And now we were talking about a real threat to downtown, not just one isolated building, but two adjoining buildings, and we're talking about a big hole in our streetscape. So I had the second petition all lined up. I put it online. I sent an email blast out about it to our, at that point, something like 1,000 members of our email list. Put out a press release, talked to the press, gave them good quotes, and went to town getting petition signatures. And I knew that although I like knocking doors, I'm a good canvasser. I was probably hired because everybody knew me because I had knocked on every door in town for various political campaigns. But I didn't have enough hours in my day to do that. Because I was told that you ought to have at least 500 petition signatures to have any impact. And my board members, as dedicated as they were, it turns out hardly anybody likes knocking on strangers' doors and saying, will you sign my petition?
Funny.
Yeah. So what I did was I spent my time going to all the local downtown business owners, and almost every downtown business owner who had a counter or a bulletin board and wasn't renting a space from this particular property owner was willing to display our petition and talk to people who were coming into their businesses. And this did two things. It made it easy to get a lot of petition signatures in a small amount of time, but maybe even more importantly, it demonstrated that the downtown community cared about preserving these two buildings, that they are, immediate stakeholders, and this was their opinion on this matter. A week later, I had 650 signatures. And I put out a big press release about that. And I touted this as clear evidence that the whole community is rallying around this. Honestly, if I had gotten 150 signatures, the press release would have looked identical because I was, whatever we had, unless it was like just my signature and my board president's, I would have said, yeah, we're doing it. And I continued to get petition signatures. But I switched my focus at that point because, okay, the online petition was going, but I had a lot to accomplish right away. And so I switched to institutional support. And so I approached many different local organizations, not just ones that you would think would be interested in historic preservation, but for example, I approached the Connecticut branch of the Sierra Club. And when I made a pitch to them, I talked about their message. I tailored my pitch to their mission. And I talked about the impact of demolition and new construction versus rehabbing an existing building. And this is tied into SHPO's current strategic plan, right, about shared stewardship. There are a lot of potential preservationists out there who don't label themselves preservationists, and I reached out to every one of them that I could think of. And I talked about heritage tourism, and I talked about economic development. And I also sent an email blast out to people and called up people that I thought might be interested in writing us individual letters of support. So I ended up with, I think, 27 letters of support. And then armed with, this growing massive number of petition signatures, eventually we had over 1,500. And I had all these letters of support. So then I thought, okay, now it's time to involve the press, not just with articles or press releases, but to get some opinion pieces generated. So I contacted a local columnist. I invited him to our office. I showed him the beginnings of alternative plans for the building. I showed him the petitions. I explained CEPA to him because at this point now I understood CEPA. And we got a very favorable column. And then I asked the editorial board of the local paper if we could have a meeting so I could explain all of this to them. And I brought all my supplies and we talked about this and we got a great editorial about the importance of preserving Bank Street's historic character and what that means to downtown. And they actually wrote that for too long people had taken Bank Street for granted and that they didn't understand the potential risk to downtown. It was a beautiful editorial. So now I have like massive growing support and I have the press and I have the institutional letter. So at this point I decided my next step was to approach elected officials. So I reached out to a city councilor that I thought would be sympathetic. And I think he chaired Economic Development Committee. And he was sympathetic, and we worked together on language for a resolution that the city council passed that would urge the Preservation Council to refer this to the state attorney general's office. And we ran it by the attorney, and I put in a bunch of whereases where I laid out the case for preserving the buildings within the resolution. And I also gave the city council an out. I said, if the Historic Preservation Council finds that there are alternative, like feasible and prudent alternatives to demolition, we then urge the council to refer, blah, blah. Because I knew that the city council would not consider themselves experts in whether this building could be saved or not. I didn't want them, and the last thing I wanted was a no vote. It would be worse, like the worst possible thing was if the city council didn't support us. That would be worse than if I had never brought it before them. And I also arranged a meeting with our mayor, and he was sympathetic, and so he wrote a letter of support, and then he agreed to be a witness later. So multi-pronged. And then the other thing was about the intensity of the support, not just the numbers. When I put the petition online, there was a space where people could write comments. I didn't have that on the in-person petitions because I just didn't think that people would take time to do that while they're standing in line at a restaurant or something. But online, people could take as much time as they wanted to express why these buildings were important to them. And we got so many heartfelt testimonials about family members who had lost buildings, homes to urban renewal, or about how they had seen the city change over the years as other historic resources had been lost. And it turns out that they expressed a lot of raw grief about the loss of historic resources in our town. And I didn't give anybody pre-supplied talking points. This all generated organically from them. I just gave them a forum in which to express themselves. And so from that, I was able to make the case, I was able to incorporate some of those quotes in my testimony to the Historic Preservation Council, so that people could weigh how much public good is at stake here. I don't think that when CEPA cases come before you, any of it is usually black and white. I think most of the times there is a hardship to the property owner who's facing a potentially expensive rehab. Who might be generating a profit with historic preservation, but not the same level of profit that he might make with demolition and new construction. So how feasible is it? How prudent, and how much does the public care? So that I thought was my role. So
Right.
it's my time. Oh,
I think just to append to your remarks, it's not a matter of how much money one makes on a project. The way I approach the litigation is I'm not trying to impose any cost on the owner. I want to make the owner successful. And the way I present it is that, yes, this prudent, feasible alternative is not what they want to do, but it does provide them with a profit. They are eligible for all types of grants and tax advantages by going into a restoration, and they can sell the building. That's an alternative.
Can I speak to that? Yeah,
Yeah.
we did look for, we organized meetings but could not attend meetings because our presence was inflammatory at this point with the property owner, but we organized meetings explaining how the property owner could make some money. Also, how the property owner could stabilize the building. If he wasn't able to sell the building for the price that he wanted, he also had the alternative of, I think it was for about $12,000 or $15,000, preventing further structural damage until the market improved and he could get more for the building. And we also searched for potential buyers for the building. We put together a whole development packet, and we did actually find people who were interested in the building who did testify eventually at the court case.
And we also, I got into a little bit with the judge that, these properties were on the register before Mr. Cornish was the owner. And he was a very renowned owners of historic buildings in the area. So I said he most likely knew this was on the register. So he took the property, he bought the property subject to the listing on the National Register. So let's not feel too sorry here about his condition. He put himself in this condition. And I think that had some sway with the judge. And that's what I try to point out in a lot of cases. Wasn't the case that you bought the property or you took the property subject to the condition that you knew about? So how can you now want to destroy it, to sell it? There's no harm to you. So I think that in the case of Mr. Cornish, that's exactly what happened. He bought the properties subject to the register nomination. So he suffers the consequences as a result. What Laura did was powerful because it really established that New London was behind this all the way through. We had Bank Street, which was an important whaling era street that they still had all their buildings there. most of them anyway. So that was very good for us. Todd?
We started the Norwalk Inn, which is a 1957, I think, 55, 57 motel looking. It has nothing to do with inn, trust me, but it's better now. Bought this building in 2000, and I just want to show you what we're talking about. One more image. This is what it looked like in 2001. Sorry for the quality, but almost 20 years old. So I happen to live around the corner. This is a real NIMBY issue. I happen to live around the corner in a really great, on a really great street that is intact. It's a 1896 to about 1920 dead-end street. And the owners of the inn invited everybody down to a party to show them the plans that they had for the site once they tore down this ugly old building on the corner. So it was pretty interesting because they had all this food out and they made their whole pitch. No one ate, no one drank, and everybody went home. Now I was a photographer then. I'm still kind of a photographer, but I was a full-time photographer, the commercial photographer. I had not thought about it. I probably couldn't spell historic preservation at that point. Went home, thought about this, and said, you know, this is a really bad idea. Now, this is a town which at the time had no preservation organization. It had and still does not have a local historic district, hence no historic district commission. We had a historical commission, but they only looked after town-owned properties. So I knew nothing. We had nothing. So I wrote up a petition, 2 sentences, saying I support the preservation of the 93 East Avenue. We didn't even have a name at that point. We knew nothing. But it was in a district. That petition eventually got over 1,000 signatures. We fought this whole thing. You talk about interveners. This was zoning meetings that went to 11 o'clock at night 2 or 3 times, ZBA meetings. We appealed every decision. We had interveners. It was a very hostile political environment. The dominant political party, whose name I will not use, used the bar of the Norwalk Inn as their clubhouse. So we had no chance in the local. I didn't know anything about CEPA. Susan Chandler, who was the historical architect at CEPA, came down, took a look at it, and started to educate. And I, of course, spread that education to everybody else. And so we were 5 years into it by the time we got to you guys. So in 2001, and these buttons said the Save 93 East Avenue. Oh, one of the reasons we got a lot of signatures, we went to the 4th of July parade, which happened to be right in front of this place. So we had about 5 or 6 people out there giving out buttons for signatures. The owner was apoplectic. So by the time we got to you guys, we had already done deed research. We took the basic building back to 1780. Obviously, it's not a 1780 building. That's the 1870 variant, post-Civil War. We documented all the owners.
The Battle of... Right. The 1779 Battle of Norwalk, burning of Norwalk. Now, this was not, I don't believe, a survivor. We thought it was at the time. And that was our PR. And I think it was bad research, but we were stuck with it by that time. It was going to be a survivor whether it was or not. So by the time we got to here, we sort of knew where we were coming from. And we came up with this
this is what we presented, and I don't, did you send this around? This is the thing that I sent you.
My
the
last,
PDF.
the last brochure had that in it.
Yeah, the
But
PDF,
I will send a PDF to Sarah to give to you all.
Right, I sent Alan a PDF of this. So this is what we brought up here, along with the petition and along with as many people as we could find who were supporters. We were well received here, thank you, and that's when Alan got involved. Now the Connecticut Trust was also involved at this point, and by then also the National Trust. So, and we had our own attorney, we had the Attorney General's office, the National Trust and the Connecticut Trust. At one point, you remember they were complaining because we had 5 lawyers
We had
in
5
court.
lawyers.
Only one of whom we were paying, fortunately. And she was soon replaced after the first a week-long injunction hearing. Silly expensive for us and even more expensive for them.
Is it typical that these cases take this long?
Yes.
Yes? Yeah.
It depends. How much legwork is done beforehand? This council cannot afford to just hear something and send it along. It's not going to happen. That's recipe for disaster. We have to take our time and do more things. Send them back for homework. Try to get involved as early as possible. Identify the alternative early. Work on the community support. All the stories that Laura and Todd have said, those are critical to the case. The courts are loath to take away property rights. We're a state of independence. We have 149 kingdoms in this.
69.
Was it 169? It's gone up. No, we have those, and they haven't changed. We're now having the real regionalization debate, which good luck with that. They all can take this long. With this case and with the Wallingford case, after the injunction was issued, that's a temporary injunction. Most of the cases go away, except when some clerk at Case Flow or one of them, they put the case on dormancy, which means that you have to bring it to a final result. The final result is a permanent injunction. And if you don't do that, the judgment goes away. It just drops off. So with Wallingford, what's that?
Say that again?
Your judgment goes away because it's temporary.
How long are they generally good for?
With Wallingford, it was good for 5 years. It depends on when they put it on dormancy. They may never put it on dormancy. But in the case of Wallingford, they put it on dormancy. So I called and I said, it's on dormancy. I have a temporary injunction. They said, yeah, you've had it for 5 years. We're going to take it off unless you bring it to permanent. So I filed permanent, and we went through the whole thing again, and then we won. So thinking about how to proceed on these things, if you have all your stuff ready, the best thing to do is go for the temporary injunction instead of the stay. You get granted the temporary up front, and then you have all this time to do the permanent, and then you only do the litigation once. I think in this age of limited resources and complex cases, that's my thinking. That's what I like to see. But it's dependent on so many other things. It depends on early community involvement, putting together the community support, identification of Shepherd, what they can do, what they bring to the table. In this case, it was formidable. And then establishing the record, identifying the prudent, feasible alternative on paper, not just selling the building. And then the record, the testimony, the newspaper articles, the petition, and then you're ready to go.
Helps who the opponent is too. In Wallingford, you're dealing with the mayor there.
It was the mayor. He
Yeah.
was
Elected forever.
He was elected forever. He was a force. no
Our guys were bad.
They were bad.
They were bad.
They're very, very smart, very
Wouldn't say that.
financed, highly financed. They weren't going to lose, and we weren't going to lose. So it was, we went out because we were better prepared than they were. And I said, you know, you're far better off trying to work this out with us than grandstanding or taking a hard position, because the litigation can go on forever, in my mind.
Susan Chandler once told me that this law, just the very existence of this law, probably saved more buildings than litigation ever did.
Exactly. That's been the experience. And I think if Todd was back here, he would attest to this, that Susan Chandler, Todd, others, never see the case. It's all worked out. In places that we've never had any problems with, it just goes away.
Yeah. And you can look at the cases, you know, the Davies Mansion with Yale.
Right.
They didn't want to go to court.
That's
state,
right.
So
Right.
they did.
Right.
That building in Milford was converted to elderly housing.
Right.
The Capitol building here, I mean.
The Warregan,
Yeah,
The
so many
Warregan,
cases,
yeah.
we didn't have to go to court.
I remember that one when we worked it out.
Yeah.
They were afraid of going to court. We were fortunate in that we had Bruce Becker, who, you know, I said, well, show them the buildings that you have. And so he got a bus, and all the council members and others went on the bus, and he went to New York City, and he showed them his stuff, and he sold them on the concept of rehabilitative. We have low-cost housing, commercial on the bottom, then you have a mixed use, and then he showed them all the grants and so forth. I mean, that's his business. He's done a number. I think he did the Capitol building. He did the Warregan.
No, that was Krosky.
That was Krosky, okay. Yeah, that's another thing. We have these great allies, Krosky, Becker, others.
Yeah, Krosky did ours.
Yeah.
Incredible, yes.
So the context of my question was that, so on the one hand, we've been saying it's really great that we don't have a lot of litigation, but in terms of getting community support and rallying your constituency, what's the role of like trying to find, like how early in the process should you even be trying to anticipate finding like a pro bono attorney who's just going to be your champion? Like where in the strategizing, like you laid out every single thing that you did, but I actually didn't hear not that much about like the legal strategy or the anticipation about possible legal.
Well, there's also the Connecticut Trust for Historic Preservation is a partner. There are statutory nonprofit partners to SHPO, and they will also have a role in hiring legal counsel. So you may not be able to get pro bono legal counsel. The Connecticut Trust will bring in Philip Walker, who represents the National Trust as well, to be that voice. So if we have a community that doesn't have a nonprofit organization like New London or Norwalk, you guys didn't even have one. You formed one to make this happen. If we're in a community that doesn't have a nonprofit organization to be the shepherd, then the Connecticut Trust for Historic Preservation will bear that cross. So they'll bear the responsibility of representing, obviously as long as there's community support, representing the nonprofit side of it. And it should be noted that our office funds the Connecticut Trust to hire the structural engineers and architects. So there'll be a bill at the end of this for 10 or 20 grand that we pay, the SHPO, or the Department of Economic and Community Development pays for by giving grants to the Connecticut Trust for Historic Preservation to pay for the architects and engineers, because we always want to get the best architects and engineers that have experience in historic places to represent preservation. We don't pay their legal fees, though. Because it's certainly us for supporting, paying for architects and engineers can still be neutral because they can go everywhere. But if we don't want to be looked at. We try to be as neutral as we can while we're collecting our evidence, so that the HBC can be neutral too. I mean, we all know that we want to preserve historic fabric. That's what we do, but we want to do it in as objective a way as we can.
If I could just add to what Todd said, if a local if a local group wants to do something litigation-wise or something, the best solution is to go through this council. Because if you vet it through this council may refer it to me or to the Attorney General, and then off we go. You don't have any legal expenses. But if you try a direct beeline to the Office of Attorney General, we're generally going to say, look, we thank you for your concern, but we vet things through this council.
And, sorry, go ahead.
I hadn't anticipated looking for a pro bono attorney until after the council had referred it to you, and then you advised us that this would be helpful if we were to gather some amici and find a pro bono attorney. Right. I did get some references from the National Trust, but it turns out the people that they referred had conflicts, and so I ended up contacting a bunch of attorneys that I thought might be sympathetic until I found one.
And the other thing is we work out, among the attorneys, we work out the work. So I tell them, look, your work demands here are going to be very, very low because I'm going to be doing most of the work. I'll prepare, whatever I prepare, I'll share with you. And then if you want to get involved, that's for you. But that's the way we did it in the Bank Street case.
In 2016, we have threatened properties on our agenda every month, and nothing ever came up about UConn. We knew nothing about it. At least I didn't. And
Right.
So at one of the meetings, Walter Woodward, the state historian, said, it was a telephone conference meeting, he said, oh, well, what's happening with UConn? I hear 9 buildings are getting demolished. And we were all like, oh, you know what? And we were all quite shocked about that. They asked to go into executive session, and Sarah said no. And so they explained that the buildings were going to be taken down, but they were under environmental policy review and subject to an MOU. And we just learned a few things about it, but it was very disjointed, and then suddenly the call was over. And so I think I asked at that point, like, what could we do to save the buildings? And Todd said, well, you can start getting signatures, and exactly like the lady said, you know, and you can get letters, and you need a grassroots effort and to show the community really wants to save the buildings. So I have no association with UConn whatsoever, so I didn't have like that in.
Do they have a shepherd?
I don't know. I guess I was shepherding at the moment. Oh, okay. I didn't know what to do. So I did what Todd said, and I tried to get, I got the signatures. Finally, we got 650. I went to UConn. I went to all the local businesses. I talked to their representatives. I went to their town hall. I mean, I just did legwork and tried to get them to write letters to Todd. They did emails and whatnot. And so we got all this material together, and then the Connecticut Trust was involved, Daniel McKay was involved, Philip Walker was involved, Todd was a little bit involved. We're all discussing the situation, like what to do. And we were kind of moving forward thinking we were going to have a case. And I wasn't necessarily going to be party to the case. I hadn't decided, but as an individual, I found out that I had the right to be if I wanted to be. So I wasn't at that point, but I was kind of organizing things because I was trying to save the buildings, because that's what we're here for. And I was here as an activist. This is why I'm on the committee. So anyway, we had a meeting at which I tried to bring it up, and it didn't really come up, and it came up at the end, but everyone had left the meeting, including the secretary. So it was kind of weird, so it wasn't really on the record that we discussed the situation. And then we had a workshop finally on August 3rd, and then we were only given a few minutes to speak. The members of the public who came weren't allowed to speak, and they weren't allowed to submit correspondence. They were told to take it off the table, so it wasn't a workshop at which the public could communicate. And so
was it a meeting or a workshop?
I think it was a workshop. I don't remember.
It was a meeting.
It was my first meeting.
Oh, lucky you. And Fox News was there. No, it was just awkward. Anyway, so whatever happened, we were given sort of presentations by Todd and Catherine about the Policy Act and the Protection Act and how they intertwined. And, it didn't sound quite right. I'm just not an attorney. I didn't know, accepted it. And then Sarah talked about sovereign immunity. And again, didn't sound quite right because Philip hadn't mentioned anything like that one in our discussions, and so but obviously we wouldn't contest it. I didn't know, and so I said at the end that I'd look into it further, and so looking into it further meant asking Philip for help, and he put together this opinion letter, and he sort of shows in the letter, if you just look at the conclusions, that the conclusions are different from those drawn from the transcript. So, I'm not saying he's right. Again, I'm not an attorney, but it's a different point of view, and I really wanted to discuss, because I don't want this to happen again. I'm going to cry.
Well, in terms of analysis, what do you think you would want to do in the future?
Well, I followed directions, so I would do the same thing, I think. But, you know, I would probably investigate first the feasibility of the project. But Philip didn't indicate that there was any reason why we couldn't refer this to the Attorney General or take our own route with the Connecticut Trust and fight it that way. So I think I was shut down by politics. I really do.
Yeah.
And I'll just say, you know, when we started this process, we as staff were under the understanding that you could still do a review under the Policy Act and reach an agreement, whereas the Protection Act was a separate entity.
Yeah.
Right.
So we were under this understanding that while we were negotiating that, this is a different avenue that you can go.
And that's what
Right.
Philip says as well.
And if the case is not, what I say ripe, I mean that we don't have all the information we need, but there's something pressing, there's deadlines pressing. The statutes provide for individuals or groups, or I think effectively maybe the Connecticut Trust, as we did with Norwalk, although he did it, going in and then the Attorney General coming in after, type of thing.
Right.
But the whole thing for us, we expect that our partner, you, will have vetted all this stuff for us. Because
Right.
we're the litigators, we're not the historians, we're not the preservationists.
Yeah, and I had all that information.
But if we don't have that, we can't go forward.
So, because I'm just going to peel back the layers on this. It was definitely a political thing. I felt that there was a power issue here. I felt that Kathleen was sitting at the table during our meeting
Right.
as a representative for, DECD as well as UConn, with the staff sitting there that certainly is loyal to their boss. Okay, putting us in an awkward position where it's the state against the state, and UConn,
That's the point.
always a bully, overpowering what was actually right. And it set off just a chain of unfortunate conversations and decisions moving forward. So it was a state against a state colliding with each other. And it put everybody on council. Well, I will not speak for everybody on council.
There was I think the Supreme Court decision came out, which has influenced, because I do work with other agencies as counsel, the Real Estate and Disability Real Estate Commission, the Appraisal Commission. The law that we implement or we follow is that boards and commissions from private citizens, made of private citizens, they make sort of recommendations to the commissioners who have the legislative power, so that, and I'm not sure how it fleshed out here, but with the Connecticut Appraisal Commission, the Connecticut Brokers Commission, and the other commissions that my colleagues work with, their decisions have to be approved by the commissioners in those respective agencies. They're not independent arbiters of a position. The position has to be in coordination, and you say, well, why in heck do they do that? This decision talked about people using their position to forestall competition or trying to increase their standing, something like that. So we, as agencies, try to follow that model, that everything flows through a commissioner. So I think in this case, maybe that's what happened. But I think we're missing the larger picture, which is, were there feasible and prudent alternatives to demolition? Isn't that the key? Mm-hmm. I mean, that's what I always tell the judge. I said, that's what you have to focus on. And the other thing is that, were there a shepherd there? Was it, just go through the questions that we presented here. Was there public benefit?
Mm-hmm. We identified such.
All those things.
All of those things were in a
That
big
you can't just take one and then hang your argument on that. You have to look
Yeah.
at the the
But
whole
we
picture.
had identified prudent feasible alternatives, and we were, we had just started the process, but we had identified them, and, we had it all set, sort of like we were developing our case, and we were moving forward, and then we were shut down. And so
Well,
that
I
was
to just throw this out,
Yeah.
not to prolong the argument, but who was going to pay for the renovation? How can you sell a building on campus to a private individual? That's out the door.
They were still using it. They were
Yeah,
still
that's right.
using it. I saw the pictures.
Yeah.
They-
That's correct.
People were
Right.
people were thrown out of the building.
They
There
were.
were still desks with stuff
Instantly.
on.
Yeah.
There was
Right.
more money in the newspaper allocated towards demolition.
Right. Was there a time to work toward the resolution? Was there sufficient time for effective litigation? Was there a compelling public benefit to the proposed project?
We thought so.
Is the owner for-profit, nonprofit, or private entity? What was the condition of the property?
Yep. So the Connecticut Trust had tried to gain entry. They did gain entry into some of them, and they analyzed some of them. And the ones that they were able to see, they thought were in fine condition. Todd even reiterated that they're okay. You know what
Yeah.
I mean? We've seen much
The
worse.
important thing for us is to consider is that as an agency, and we're in an agency, that we speak with one voice, and who
Right. If we have a decision.
ultimately decides that.
Right.
So I'll
You
just
know.
add that through the Policy Act, the University of Connecticut had met with their Historic Preservation Commission. They had met with the Historical Society. They had met with members of the public. There was transcripts of all of this where they disclosed what their plans were. It went through an environmental assessment document that was approved through the Office of Policy Management. Because they went through and completed that process, and because there was full transparency given to the public and an opportunity to comment, and nobody at that time said anything, they were able to fall back on the fact that they went through a legal process that gave to them a conclusion. And so when the idea of a Protection Act was brought up, there was a lot of pushback on how those two laws align. Because UConn felt like they went through a process and had given everybody, including our agency, opportunities to comment, and at that time, there was no response to what they were proposing.
There's another thing too, and this is a question for you, Alan. Would there be a case where a state agency, the Attorney General's office, sue another state agency?
No.
No, right? That would never happen.
So when we were
Well,
thinking
I'm not saying
about
never happened, but no.
We could not.
Right, but the sovereign immunity, forget for a
I would not have
second.
promoted that because it says very clearly
You'd have to
any
do it on your
individual
own.
could
That's
sue.
correct.
But when we looked at it as an agency, would we refer this to the HPC? We had a prior memorandum of understanding between our office and UConn that they could have pulled out on us, but clearly they forgot about it. Our office knowledge, and we just happened to find the document afterwards. They had gone through an environmental review process where they gave presentations to the preservation communities there and historical societies, and nobody said anything. And so we thought those two things alone would be difficult for us to then go to the Attorney General and say, yeah, you should fight this, even though when we were given the opportunity, we didn't put up a great fight. And then there's the thing of Ellen would have to go up it'd be state versus state.
Right, but you have the public support at that juncture. And then, as Philip said, signed MOU, an environmental policy review doesn't preclude the Protection Act.
Right, but
For individuals.
right. But you could have, or your
Right.
group could have,
And the
but
Connecticut Trust could have.
The Connecticut Trust
Yes.
could have, but the Attorney General's office is not going to.
Perhaps not, but I
Because,
wasn't
well, they won't
asking
because they're
them
not
to.
going to ever say a state agency, state against state.
Right.
They're never going to fight. Attorney General. It would be one Attorney General against another Attorney General in a court to battle. That's not going to happen. They're the same thing.
But I guess what I'm saying is they are distinct. Policy Act and Protection Act are distinct. And I think during that August 3rd meeting, there was a lot of overlap.
There is overlap,
Well,
because the reason why we review things under the Policy Act is for the same exact reasons why they are protected under the Protection Act, because these are items that are meant to be in public
But it
trust.
doesn't bar a Protection Act action.
No.
But it
Oh.
says so in a few places, but.
No, but for our office to have recommended it to go to HPC and go to the Attorney General, that would have been not possible, it would not have made sense for us. That, we would have brought that law, even if it went through the process, it would have gone to Alan and he would have said, I don't take losing cases, and I don't think you have a good leg to stand
Well,
on.
it would be vetted through the office. I'm just telling you what my reaction would be, or my recommendation. I would say absolutely, I'd make no recommendation to take this forward.
Right.
But
So,
other people could overrule that in the office, but I don't think so.
But if you went to court as it's a Connecticut Trust,
Yeah,
who do you think they're going to subpoena to testify?
well,
But we have already made an agreement
Yeah.
to allow demolition.
Exactly.
It would have been a
So
very
you're having an
difficult case.
in-family fight. And
So-
does that favor historic preservation
I
as
don't know,
a
but
So they
submission?
say it was
It's
too
not
late.
saying that one law
It was
precludes
too
you from
late.
the
Right.
other. It would be very difficult to win a
Right.
Protection Act case for something that has come to a logical conclusion through the
but
Environmental
when
Policy
I
Act.
read all the FOI documents, I saw that that MOU signing was very rushed at the end.
It was.
So it was not,
Listen,
I think they
Todd
did
and
it
I
within a
have-
couple of
we gave
days. when they
nicknames.
did
He's argumentative,
things
I'm
with-
cantankerous.
Yes.
I'm not gonna lie that we fought tooth and nail to the
Yeah.
best that we thought we were within
But then
the legal
Christina-
guardrails to do it.
But she said, let's get this puppy signed and go out for lunch. That's specifically what she said.
So what we've learned from
And
this,
it's not okay.
so it's not,
Going
okay. What we've
forward.
learned is this, is that if we're going to conclude an environmental review that has a potential for a CEPA case, then we have some decisions to make. Because if we conclude environmental review over the Policy Act, and we come to a conclusion, an MOA, or MOU, or PA, or whatever it is,
Yeah.
then we can't, as an agency, do Protection Act. We can't, as an agency, gather information and bring it to HPC to bring it to the Attorney General's.
But that
We
leaves
can't.
our state-owned resources unprotected, because you can have a nice quiet.
But let me just finish.
Yeah.
But if we know that there's a possibility for that,
Right.
then we have an opportunity to, I guess, I'm not exactly sure how it would work, but not make a decision under the Policy Act so that the Protection Act can go forward.
Okay, let's just conclude with the last solution for the church. Do you have something?
so we looked at the church brief, and we looked at the list of the questions, and there were a few things that popped out to us, that facts that were missing from the brief that we would need additional information on. So the buildings are listed on the National Register as part of the district. We don't know if they continue to be contributing resources. That wasn't identified, but that would be something that the Preservation Board would need to weigh in on.
Or we'd at least need that nomination and some understanding of what it looked like, how much that integrity is still there. And then the problem was that at the moment, the public group, there is a shepherd, but there's only 12 people, if I'm reading this right. And that the deferred maintenance is pretty prohibitive for the original idea, which was to have multiple congregations come in. And also that the developer's plan does have public interest, public good.
This is based on a real case. And what the judge decided in that case was he found for really all the arguments that the plaintiff made, or the
Save the Church.
Save the Church made, but found that given the size of the congregation and the amount of money needed, that it wasn't reasonable to, what can you can't really sell a church. He decided in favor, without much else, to allow the demolition.
No other ideas for.
Yeah, the thing about
saving
that
the
case
building,
was
yeah.
that I don't think it was developed properly. I think when the lawyer called me about it, I said, I think you really need to do more homework. You need to sharpen that pen, because you're dealing with a church, one, a school, a hospital. You have three entities that will cause you a lot of problems. They could have done with which a lot of congregational churches do now, who have very small memberships, but they have a huge building to take care of. They do community outreach, and they do. That would have been my approach.
I'm on a board where the congregation
I was
sold it
shown
to
as a
nonprofit.
principal and food alternative that this is done commonly, Although people are not members of the church, they do contribute to the support of the upkeep of the church because it's a symbol in the community. At least congregational churches are. And because they were used to be former seats of government in the colonial days. And they go through a capital campaign. And the capital campaign is not focused on the congregants. It's focused on the community wide. And they usually raise the money and get there. And then they come through this organization for additional grants, and it all works out. That would have been my approach to that case. I think when they presented the case, they didn't develop that alternative. And that's why I'm saying that's really the only inquiry that the court should engage in is prudent, feasible alternatives. Where are they?
That was Waterbury?
I think it was Waterbury,
Yeah.
right.
Same story, there's never been any shepherds there
No shepherds.
in Waterbury.
So you can't fudge the requirements for a successful CEPA case. You got a strong law. There's an equally strong resistance to taking away property rights. You have abundant resources that you have to develop. And as Laura and Todd has pointed out, it's hard work. But if you're willing to do it, you'll get a good result. And what can this council do? Just continue your good work, follow your process. Don't just try to rubber stamp something and ship it off because it's going to go nowhere. You have to develop it. I know that with the Bank Street case, I thought it was a little bit rushed, to be honest. And we didn't have a clear shepherd. I identified Laura as the shepherd. And we developed the case, but the case was developed during trial. And that's not what you want to do. What Jack and Bill Foudy and others have done, and Sarah as well with the Cheney case, you send them away with homework to do. The building's going to stay up, or you have guarantees of it staying up, and have them come back. Have them time to think about what you told them. Have this period in which they can come back to you. And I found that when they first show up, they have a chip on their shoulder. Bless you. And the second time they come, they're more willing to talk about the problem. So that's what I have. Sarah, do you have any closing?
Well, there are two things. And one is that, as you've heard alluded to, next week, we actually, at our meeting, we do have a Protection Act matter, which involves 2 buildings in downtown Willimantic. What we are choosing to do is we are going to conduct our meeting in Willimantic to afford council members an opportunity to see the context, which is incredibly important, particularly in this case, and to be able to be present and accessible for a very large number of people who want to be able to hear with regard to this matter. The meeting time will still be 9:30 as our regular meeting time. We will conduct our business portion of the meeting in the first hour. There will be a break, and then we will have this CEPA hearing. So that's the first thing that I just wanted to tell you about. And as Todd said, the information will be coming out by the end of the week with some sort of organizing document, which sort of, this is the history, these are the press reports, these are the engineering reports. So that is number one. Number two, and Alan, forgive me for going back to this, but we still didn't completely answer one of the things that Margaret actually found from Philip Walker. And I want to step backwards for a second and say, I didn't make the decision not to put it on the agenda on my own volition without legal counsel and responding to what every interested person who knew about this legislation told me without exception, which is, given the details of this particular case, you cannot put it on your agenda. And it is the state versus the state, and the state has sovereign immunity. And I have to rely upon the legal expertise that is afforded to me.
Fair enough.
That is the decision. It was no personal decision, and I spent...
You said you were counseled, but you had counsel. right, council.
Yes.
So, yeah, we just have a different opinion here, so, you know.
I lost sleep for 2 months.
I'm still sick about it.
So-
I still could cry.
Very therapeutic.
Can I just throw out there one last thing to end with? We win most of the time. The losses hurt and stick with you. Todd and I still have sore feelings about the brown houses to this day, but we win a lot more than we lose. And we should feel, you guys should all, because you're part of it, feel good about that.
And there's a lot of cases that you guys just don't hear, because the threat of going in front of you guys is enough for them to come to the table and come to an agreement to save the buildings.
And that's because we bring quality cases to be tried. And those send a very chilling effect. The Bank Street case, as I said before, I've heard a lot of developers are backing away because of what happened on Bank Street.
Good.
Thank you.
Well, thank you. If you have any questions, see me after or give me a call, whatever.